Hello and welcome to North Star Oasis. I'm your host, Jeff Williams. We're here at the top of the hour for another jam-packed episode. I have to mention that last week we came into the studio, and that was when we found out that Supreme Court Justice Antonin Scalia had passed away. We elected to run a replay instead, as our staff and myself, we were busy assessing the situation and the ramifications on what's going to happen with our government. One thing I have to say is I think that even though Justice Scalia passed away, President Obama may have thought that he may have just been handed a Christmas present. There's 308 shopping days left until Christmas, but when you have an opportunity to pick one more nominee to the Supreme Court, yeah, that's kind of a Christmas present that I don't think he foresaw coming. Yeah, that's what we've been wrapped up with all week long, trying to figure out how to present the facts of this week and the ever-shifting statements from Republicans and Democrats to make sure that you, the loyal viewers of North Star Oasis, are well informed to have those office cooler discussions with all of your friends and your family and your colleagues. Before we move on to Supreme Court pressing matters, with an election coming up and 47 more weeks before the next presidential inauguration, yes, we're down to 47 more weeks, we do usually put a quick spotlight on candidates, especially ones who have shown up in Minnesota. Today is a election day in South Carolina for the Republicans, and just a quick look at the Real Clear Politics average of polls. It looks like Donald Trump is in the lead in South Carolina, but Marco Rubio has just surpassed Ted Cruz for second place, and Jeb Bush is a distant third. Kasich and Carson are behind him. So what this tells me is that on the delegate math, take a look and see tonight how closely things are. And if you're watching this on a rebroadcast, just go back and think back to what you were doing on Saturday night, or just do a quick look online at the results. You'll find that it's going to be interesting to see from Trump to the second place finisher what that gap is, and then whether or not Rubio or Cruz ends up with a second place finish, and then what is the delegate math like? There's 50 delegates up for grabs in South Carolina. On the Democratic side, today they are in Nevada at the Nevada caucuses, and it is a neck-and-neck tie between Bernie Sanders and Hillary Clinton. There are 43 delegates up for grabs in Nevada, so it's going to be interesting to see what happens there at the end of the night. And then the roles reverse on Tuesday, when the Republicans go to Nevada, and there's going to be 30 delegates up for stake there. And again, it's Trump in the lead with Cruz and Rubio essentially tied for second. And then the Democrats on Tuesday will be in South Carolina. There's 59 delegates up for grabs. And that one, right now, it looks like Hillary's going to have about a 2-to-1 advantage over Bernie. However, after today, and the focus goes on to South Carolina, I do expect to see that be a little bit closer. And hey, we're the ones who told you back in April that Bernie Sanders is going to be a force for Hillary Clinton to reckon with in this nominations contest, and that's exactly what it's shaping up to be. And speaking of Hillary Clinton and Bernie Sanders, both of them were in town on Friday, the 12th of February, so it was just before last week's show, and we've got footage. Let's take a look at the video. This is the Humphrey Mondale dinner from the DFL at the St. Paul River Center on Friday the 12th.
Assalamu alaikum.
Shalom aleichem.
This is my good friend, Imam Hamdi al-Sawaf.
And this is my friend, Rabbi Michael Adam Latz. In the name of God, most gracious and most merciful, the cherisher and the sustainer of the whole universe. It's really an honor to be with all of you tonight. It's really an honor to be with all of you tonight, and I repeat, as the president of the board of the Islamic Community Center of Minnesota, as an imam, spiritual leader of our mosque, Masjid al-Iman, or Mosque of Faith, and as a psychotherapist as well, I love to share with you how many of our members of our community, sorry to say, have been suffering. Our children, boys and girls, our mothers, sisters, wives, who have been wearing, especially the mothers, sisters, and wives, their hijab, their headscarf, have been suffering a lot from that Islamophobia against Muslims and against Islam.
Ladies and gentlemen, please welcome to the stage Democratic presidential candidate, United States Senator Bernie Sanders.
Thank you.
Okay. I'm going down.
Thank you. Thank you. It sounds like some of you are ready for a political revolution. All right. So I can sit here for 10 hours, that's right. I can sit here for 10 hours and telling you all the things that are wrong and all the things that have to be done. But I'll be wasting your time because nothing significant gets done unless millions of people come together, including working people who have given up on the political process, young people who have never been involved in the political process, African Americans and whites and Latinos and Native Americans, Asian Americans, gay and straight, men and women, young and old. Unless we revitalize American democracy so that we have one of the highest voter turnouts in the world, not one of the lowest voter turnouts in the world. And when millions of people get involved in the political process and look at Washington and say, you know what? Our government belongs to all of us, not just a handful of wealthy campaign contributors. When that happens, we transform America. Environmental movement didn't happen in Washington by some senator introducing legislation. It happened because people saying, what is going on this precious planet of ours? You can't destroy it. We've got to protect the planet. And you think about something like gay rights. If we were sitting here 10 years ago, and somebody said, you know, I think that in 2015, gay marriage will be legal in 50 states in America, the person next to him would have said, what are you smoking? What the political revolution is about is the belief that, yes, when we stand together, when we do not allow the Trumps of the world to divide us up, yeah, there is nothing that we cannot accomplish. I ask you to join the political revolution. Thank you all very much.
Ladies and gentlemen, please welcome to the stage Democratic presidential candidate, Secretary Hillary Clinton.
This is my fight song. Take back my life song. Prove I'm alright song.
wonderful to be here, reunited with so many friends, supporting the DFL in a state with such a long, proud, progressive tradition. Now, so many Minnesotans have inspired us with principled leadership. Hubert Humphrey, Walter Mondale, and the late, great Paul Wellstone. I had the great honor of serving with Paul and Sheila and spending a lot of time on the floor of the Senate talking with him about what we wanted to see happen to improve the lives of the people we represented. And I've thought a lot about him in the last months. He was a true progressive who wanted to get things done, who wanted to make progress, and I miss him, and I thank you for sending him to serve. My friends, I am not a single issue candidate, and this is not a single issue country. We need a president who can do all parts of the job on behalf of all Americans, who believes in the basic proposition about our country, that when each and every American has the chance to live up to their own God-given potential, then and only then can America live up to its potential. With your help, we can build that future together. Please join me on March 1st. Thank you all for everything you are doing to make sure we move with confidence and optimism into the future that we shape. Thank you all very much.
Ladies and gentlemen, thank you for attending the Humphrey Mondale Dinner.
And that was the Humphrey Mondale Dinner on Friday, February 12th at the St. Paul River Center when Bernie Sanders and Hillary Clinton were in town. Now, we did put up on our YouTube channel, youtube.com/North Star Oasis, the complete speech between both of those candidates. We just didn't have time with all the other stuff we've got to cover today. We just didn't have time to show you both of their full speeches. So we do have, I think it's like an hour and 15-minute video, which shows some of the other stuff that happened. We cut out all of the local political speeches and just gave you the two national candidates instead. And then we do have some Nevada caucus returns that have been coming in with 61%. It's looking like it's a 52-48 race in favor of Hillary Clinton right now, and the delegate counts are even at 9 apiece. There's 35 delegates up for grabs, 18 have been allocated, 9 for Hillary Clinton, 9 for Bernie Sanders. And now we're going to turn the page because we've got a lot of court issues to discuss. And we're going to actually show you what happened after, literally, while the world was still spinning its head trying to figure out the aftermath of Justice Antonin Scalia's passing. Let's take a look at what happened on the political scene regarding that.
Supreme Court Justice Antonin Scalia died yesterday. It was unexpected. As the shock of his passing tore through Washington, the Republicans in the Senate took to the airwaves on Sunday morning to vow that President Obama's nominee to replace Scalia will never get to the bench. 5 minutes after the confirmation of Scalia's death on Saturday, top GOP politicians began to telegraph their refusal to consider any Obama nominee. Senate Majority Leader Mitch McConnell and Senate Judiciary Committee Chair Chuck Grassley both said that the next president, not Obama, should be the one to nominate a successor to the conservative titan.
McConnell has sent an indication that essentially anything that Obama does is dead on arrival. Now, if you take a look at the Constitution, it states that the president shall nominate with the advice and consent of the Senate, Supreme Court nominees. The Senate, of course, can't restrict the president's right to appoint, but that doesn't necessarily mean that they have to actually do the confirmation during this next year. So this is something that we're going to have to be watching closely in the next year, really, because this is going to be a historical moment that we're living through, because with however this process plays out, it's probably going to have some long-term repercussions and ramifications in how we view judicial nominations and Supreme Court appointments in particular from here on out. But now let's take a look at what President Obama had to say. He was at a press conference in California, I believe on Wednesday, and there were two questions, and it had to do with some Southeast Asian trade group or U.S. Asian trade group. And I watched a whole press conference when doing show prep this week, and I'll tell you, it was a long press conference. Only two questions came out about the Supreme Court. So we're going to take a look at one of them. I am going to offer some commentary, so I would like to have my microphone up through this section. And let's take a look at what President Obama has to say about the selection process.
So with that, let me take a few questions, and I'm going to start with Darlene Superville of the Associated Press. Where's Darlene? There she is.
Thank you, Mr. President. My question is about the Supreme Court.
I'm shocked.
What recourse do you have if Leader McConnell blocks a vote on your Supreme Court nominee? And do you think that if you choose someone moderate enough that Republicans might change course and schedule a vote? And as you consider that choice and who to nominate, what qualities are important to you and is diversity among them? Thank you.
First of all, I want to reiterate heartfelt condolences to the Scalia family. Obviously, Justice Scalia and I had different political orientations and probably would have disagreed on the outcome of certain cases. But there's no doubt that he was a giant on the Supreme Court, helped to shape the legal landscape. He was, by all accounts, a good friend and loved his family deeply. And so, it's important before we rush into all the politics of this to take stock of somebody who made enormous contributions to the United States. And we are grateful not only for his service, but for his family's service. The Constitution is pretty clear about what is supposed to happen now. When there is a vacancy on the Supreme Court, the President of the United States is to nominate someone. The Senate is to consider that nomination, and either they disapprove of that nominee or that nominee is elevated to the Supreme Court. Historically, this has not been viewed as a question. There's no unwritten law that says that it can only be done on off years. That's not in the constitutional text.
Okay, hold on. Stop the tape right here. There's no unwritten law. Now, let's take a look at what happened in August 1960. The Democrats in the Senate, they had passed, and I wrote notes here, Senate Resolution 334. And it reads, quote, expressing the sense of the Senate that the President should not make recess appointments to the Supreme Court except to prevent or end a breakdown in the administration of the court's business. That even though it wasn't the full appointment but only a recess appointment, the fact is 48 Democrats said yes, 33 Republicans and 4 Democrats said no. This was in August of 1960. And it wasn't just an unwritten law, it was actually written down. Senate Resolution 334. This, I think, is because the president either does not know history or he just doesn't want you to know that he knows. Let's go back to the president's remarks.
I'm amused when I hear people who claim to be strict interpreters of the Constitution, suddenly reading into it a whole series of provisions that are not there. There is more than enough time for the Senate to consider in a thoughtful way the record of a nominee that I present and to make a decision. And with respect to our process, we're going to do the same thing that we did with respect to Justice Kagan's nomination and Justice Sotomayor's nomination. We're going to find somebody who is an outstanding legal mind, somebody who cares deeply about our democracy and cares about rule of law. There's not going to be any particular position on a particular issue that determines whether or not I nominate them, but I'm going to present somebody who indisputably is qualified for the seat, and any fair-minded person, even somebody who disagreed with my politics, would say would serve with honor and integrity on the court. Now, part of the problem that we have here is we've almost gotten accustomed to how obstructionist the Senate's become when it comes to nominations. I mean, I've got 14 nominations that have been pending that were unanimously approved by the Judiciary Committee. So Republicans and Democrats on the Judiciary Committee all agreed that they were well qualified for the position.
Okay, stop the tape right here. I've got 14 nominations that have been pending. President Reagan in 1987, he had 27 who were pending. For federal appellate nominees in the first term, President George W. Bush had 67% success rate. President Clinton had 71% success rate. President Reagan had 85% success rate. I don't know what President Obama's success rate is. I wasn't able to find that statistic. Here's another thing. Miguel Estrada, who was appointed or nominated to the D.C. Court of Appeals, which is usually one of the last steps before being appointed to the Supreme Court, he waited for 2.5 years after President Bush, George W. Bush, had appointed him or nominated him for the position before he finally just said, I've had enough, and grew tired of waiting and withdrew his nomination. 2.5 years. And so the president is complaining about 14 nominations that have been pending. This, folks, is politics. Both parties do it. It's that way all the time. Let's go back to the tape.
And yet we can't get a vote on those individuals. So in some ways, this argument is just an extension of what we've seen in the Senate generally, and not just on judicial nominees. The basic function of government requires that the President of the United States, in his or her duties, has a team of people, cabinet secretaries, assistant secretaries, that can carry out the basic functions of government. It requires, the Constitution requires, that we appoint judges so that they can carry out their functions as a separate branch of government. And the fact that we've almost grown accustomed to a situation that is almost unprecedented, where every nomination is contested.
Okay, hold on.
Everything
right
is
here. Everything is contested. Why is that? And how long has this everything has been contested and going on? Well, actually, we've got an answer. We're going to show you that a little bit later here. But that's why I just wanted to stop there briefly, because the President has said we've grown accustomed to the situation where every nomination is contested. Yes, that is actually true. And we're going to get into that in just a moment here. Let's go right back to the last section of this video.
Regardless of how qualified the person is, even when there's no ideological objection to him. Certainly where there are no disqualifying actions by the nominee that have surfaced. The fact that it's that hard that we're even discussing this is, I think, a measure of how, unfortunately, the venom and rancor in Washington has prevented us from getting basic work done. Now, this would be a good moment for us to rise above that. I understand the stakes. I understand the pressure that Republican senators are undoubtedly under. I mean, the fact of the matter is that what the issue here is that the court is now divided on many issues. This would be a deciding vote, and there are a lot of Republican senators who are going to be under a lot of pressure from various special interests and various constituencies and many of their voters to not let any nominee go through, no matter who I nominate. But that's not how the system's supposed to work. That's not how our democracy is supposed to work. I intend to nominate in due time a very well-qualified candidate. If we are following basic precedent, then that nominee will be presented before the committees, the vote will be taken, and ultimately they'll be confirmed. Justice Kennedy, when he was nominated by Ronald Reagan, in Ronald Reagan's last year in office, a vote was taken, and there were a whole lot of Democrats who I'm sure did not agree with Justice Kennedy on his position on a variety of issues.
Okay, hold on. Let's address this real quick here. Kennedy, in his last year, in Reagan's last year of office, that was because he was the previous nominee was Bork. Well, actually, the nominee before that. Yes, Judge Bork, Robert Bork, lost the nomination. The Senate did not confirm him. After that, in October of '87, after that vote, the President Reagan appointed Douglas H. Ginsburg as the next nominee. And then under allegations that he was using marijuana after as an, I think, an associate judge, or at least as a law professor. He withdrew his nomination very quickly. And then Anthony Kennedy, who did get confirmed, he was actually appointed, nominated on November 11th, 1987. And so, yes, while the confirmation actually did occur in 1988, he was nominated in 1987. So in this case, I think the president is playing a little too loose with the facts. Let's go back to his statement.
But they did the right thing. They confirmed him. And if they voted against him, they certainly didn't mount a filibuster to block a vote from even coming up. This is the Supreme Court, the highest court in the land. It's the one court where we would expect elected officials to rise above day-to-day politics. And this will be the opportunity for senators to do their job. Your job doesn't stop until you're voted out or until your term expires. I intend to do my job between now and January 20th of 2017. I expect them to do their job as well.
So now he talks about senators have to rise above day-to-day politics. Well, President Barack Obama was a United States senator. So how did he handle it on the day-to-day politics, and whether or not he rose above that when President George W. Bush had nominated Samuel Alito as a Supreme Court justice? Let's take a look.
I understand that Judge Alito is going to be here a little later today. Can you tell us your concern about him?
Judge Alito is a very capable and intelligent judge. If you look at his track record, however, it appears that he believes in an unconstrained executive branch and does not seem to have much concern or regard for the most vulnerable in our society. And that's the reason that I'll be voting no against him.
Thank you.
All right. Thanks, guys.
So now, what did President Obama, then Senator Obama, say after he had just voted against Samuel Alito as the Supreme Court Justice. Let's take a look.
Mr. President, first of all, let me congratulate Senator Specters and Leahy for moving yet another confirmation process along with a civility that speaks well of the Senate. As we all know, there's been a lot of discussion in the country about how the Senate should approach this confirmation process. There are some who believe that the President, having won the election, should have complete authority to appoint his nominee, and the Senate should only examine whether or not the justice is intellectually capable and an all-around good guy. That once you get beyond intellect and personal character, there should be no further questions as to whether the judge should be confirmed. I disagree with this view. I believe firmly that the Constitution calls for the Senate to advise and consent. I believe that it calls for meaningful advice and consent that includes an examination of a judge's philosophy, ideology, and record. And when I examine the philosophy, ideology, and record of Samuel Alito, I am deeply troubled. Now, I have no doubt that Judge Alito has the training and qualifications necessary to serve. Has been already stated. He has received the highest rating from the ABA. He's an intelligent man and an accomplished jurist. There's no indication that he's not a man of fine character. But when you look at his record, when it comes to his understanding of the Constitution, I found that in almost every case, he consistently sides on behalf of the powerful against the powerless, on behalf of a strong government or corporation against upholding Americans' individual rights and liberties. If there's a case involving an employer and an employee, and the Supreme Court has not given clear direction, Judge Alito will rule in favor of the employer. If there's a claim between prosecutors and defendants, if the Supreme Court has not provided a clear rule of decision, then he'll rule in favor of the state. He's rejected countless claims of employer discrimination, even refusing to give some plaintiffs a hearing for their case. He's refused to hold corporations accountable numerous times for dumping toxic chemicals into water supplies, even against the decisions of the EPA. He's overturned a jury verdict that found a company liable for being a monopoly when it had over 90% of the market share in that industry at the time. It's not just his decisions in individual cases that give me pause, though. It's that decisions like these are the rule for Samuel Alito rather than the exception. When it comes to how checks and balances in our system are supposed to operate, the balance of power between the executive branch, Congress, and the judiciary, Judge Alito consistently sides with the notion that a president should not be constrained by either congressional acts or the check of the judiciary. He believes in the overarching power of the president to engage in whatever policies the president deems to be appropriate. As a consequence of this, I'm extraordinarily worried about how Judge Alito might approach the numerous issues that are going to arise as a consequence of the challenges we face with terrorism. There are issues like wiretapping, monitoring of emails, other privacy concerns that we've seen surface over the last several months. The Supreme Court may be called to judge as to whether the president can label an individual U.S. citizen an enemy combatant and thereby lock them up without the benefit of trial or due process. There may be considerations with respect to how the president can prosecute the war in Iraq and issues related to torture. In all of these cases, we believe that the president deserves our respect as commander-in-chief, but we also want to make sure that the president is bound by the law, that he remains accountable to the people who put him there, that we respect the office and not just the man, and that that office is bounded and constrained by our Constitution
and our laws. And I don't have confidence that Judge Alito shares that vision of our Constitution. In some, I've seen an extraordinarily consistent attitude on the part of Judge Alito that does not, I believe, uphold the traditional role of the Supreme Court as a bastion of equality and justice for United States citizens. Should he be confirmed, I hope that he proves me wrong. I hope that he shows the independence that I think is absolutely necessary in order for us to protect and preserve our liberties and our freedoms as citizens. But at this juncture, based on a careful review of his record, I do not have that confidence, and for that reason, I will vote no and would urge my colleagues to vote no on this confirmation. Thank you very much, Mr. President. I yield back my time.
That was January 2006 with then Senator Barack Obama. Wow. He states there is no indication that he is not a man of fine character. He talks about how he is learned in law. He's an intelligent man. These are the very things that everybody states should be worthy of Supreme Court nominations. Should be confirmed because of the application of the rule of law. In other words, President Obama was saying, do as I say, not as I do. It's really what it comes down to. Pay attention to what Robert Bork will say a little bit later on in our show on privacy matters. At that same time, in January of 2006, Hillary Clinton was also a U.S. Senator. She also stood up and discussed Samuel Alito's nomination. Let's take a look.
The Constitution commands that the United States Senate provide the President with meaningful advice and consent on judicial nominations. And I take this constitutional charge very seriously. I have carefully reviewed the committee's hearings and Judge Alito's extensive record. I've met with the judge. I've spoken with people who have strong opinions on both sides of this nomination. And I have concluded that I cannot give my consent to his nomination to the Supreme Court.
Folks, it's because Samuel Alito did not share the same political ideology as Hillary Clinton or Barack Obama. That's really what it came down to. It has nothing to do with whether or not Samuel Alito was learned in the law, the requirement of the U.S. Constitution. It didn't require nothing about whether or not he was an intelligent man or fine character, capable of doing the job. Really, it just comes down to the fact that, George W. Bush appointed him, and so therefore we're going to not nominate him, or we're going to vote no against him in the nominations process just because he's a Republican, not because there's anything really wrong with him. That's really what I got from the Alito hearings. And now I bring up the Alito case because in that second question at Wednesday's press conference, that was actually brought back up again. Let's take a look.
All right. Let's see who we got here. Jeff Mason.
Thank you, Mr. President. Following up on that, should we interpret your comments just now that you are likely to choose a moderate nominee? Would you consider?
No.
Okay.
I don't know where you found that. You shouldn't assume anything about the qualifications of the nominee, other than they're going to be well qualified.
All right.
Okay.
Following up,
Yes.
would you consider a recess appointment if your nominee is not granted a hearing?
I think that we have more than enough time to go through regular order, regular processes. I intend to nominate somebody, to present them to the American people, to present them to the Senate. I expect them to hold hearings. I expect there to be a vote.
That means no recess
Full
appointment.
stop.
And lastly, as long as we're doing this in a row, how do you respond to Republican criticism that your position is undercut by the fact that you and other members of your administration who were in the Senate at the time tried to filibuster Judge Alito in 2006?
Look, I think what's fair to say is that how judicial nominations have evolved over time is not historically the fault of any single party. This has become just one more extension of politics. And there are times where folks are in the Senate and they're thinking, as I just described, primarily about, is this going to cause me problems in a primary? Is this going to cause me problems with supporters of mine? And so people take strategic decisions. I understand that. But what is also true is Justice Alito's on the bench right now. I think that historically, if you look at it, regardless of what votes particular senators have taken, there's been a basic consensus, a basic understanding that the Supreme Court's different. And each caucus may decide who's going to vote where and what, but that basically you let the vote come up and you make sure that a well-qualified candidate is able to join the bench, even if you don't particularly agree with them. And my expectation is that the same should happen here. Now, this will be a test, one more test, of whether or not norms, rules, basic fair play can function at all in Washington these days. But I do want to point out, this is not just the Supreme Court. I mean, we have consistently seen just a breakdown in the basic functions of government because the Senate will not confirm well-qualified nominees, even when they're voted out of committee, which means that they're voted by both parties without objection. And we still have problems because there's a certain mindset that says we're just going to grind the system down to a halt. And if we don't like the president, then we're just not going to let him make any appointments. We're going to make it tougher for the administration to do their basic job. We're going to make sure that ambassadors aren't seated, even though these are critical countries and that may have an effect on our international relations. We're going to make sure that judges aren't confirmed, despite the fact that Justice Roberts himself has pointed out there's emergencies in courts around the country because there are just not enough judges and there are too many cases, and the system's breaking down. So this has become a habit, and it gets worse and worse each year. And it's not something that I have spent a huge amount of time talking about because, frankly, the American people on average, they're more interested in gas prices and wages and issues that touch on their day-to-day lives in a more direct way. So it doesn't get a lot of political attention. But this is the Supreme Court, and it's going to get some attention. And we have to ask ourselves as a society a fundamental question, are we able to still make this democracy work the way it's supposed to, the way our founders envisioned it? And I would challenge anyone who purports to be adhering to the original intent of the founders, anybody who believes in the Constitution, coming up with a plausible rationale as to why they would not even have a hearing for a nominee made in accordance with the Constitution by the President of the United States, with a year left practically in office. It's pretty hard to find that in the Constitution.
But I'll tell you where we can find it after we show you Josh Earnest, the White House press secretary, doing a little bit of backtracking for President Obama. Let's take a look. Very short clip.
As the president alluded to yesterday, he regrets the vote that he made because, frankly, I mean, as we've discussed, Democrats should have been in a position where they were making a public case. That's what Democrats should have done, and they shouldn't have looked for a way to just throw sand in the gears of the process. And frankly, looking back on it, the president believes that he should have just followed his own advice and made a strong public case on the merits about his opposition to the nomination that President Bush had put forward.
Okay, you heard President Obama, then Senator Obama, on the floor of the U.S. Senate. You saw a small clip of his press conference outside in 2006, 10 years ago, and then you heard the press conference that the entirety of the remarks of the president in two clips of his remarks addressing the current Supreme Court situation in which Josh Earnest had replied to. Did you hear a regret or an apology for the president's actions 10 years ago when you were watching that? I didn't hear it. I missed that if it was there. And so a little disingenuous there. However, Josh Earnest is right. The president should have, practiced what he preaches, and the Democrats in the Senate should not have thrown sand in the gears of the judicial nomination process, which is exactly what they did. Now, the president wants to come out and say, well, how do we get here? It shouldn't be this way. Well, I'll tell you, here is where the precedents, as far as the Republicans in the Senate saying, we're not even going to consider a nomination. We're not going to consider it until after the election. Here's where that stems from. 2007, a speech from U.S. Senator, Democrat in New York, Chuck Schumer. Let's take a look.
That we should not confirm any Bush nominee to the Supreme Court except in extraordinary circumstances. They must prove by actions, not words, that they are in the mainstream, rather than we have to prove that they are not. So in conclusion, in the end, these three questions provide the foundation for thinking about how we ensure that our court reflects what America wants, rather than a diminishing clique of conservative ideology, rather than what a diminishing clique of conservative ideologues wish for. There's no doubt we were hoodwinked. Let me remind you of one particular striking passage from Justice Roberts' confirmation hearings. Senator Graham asked him, quote, "The idea of a dramatic departure under your watch from the Rehnquist era is probably not going to happen. Is that true?" Roberts responded, "Given my view of the role of a judge, which focuses on appropriate modesty and humility, the notion of dramatic departures is not one that I would hold out much hope for." Of course, now, only a short while later, we have a better understanding. There is no way to say it better than Justice Breyer. It bears repeating. "It is not often," he said, "in the law that so few have so quickly changed so much." And this somber judgment after just one full term of Roberts and Alito. This is just a prologue, considering the constitutional harm and dramatic departures that are in store if those few are joined by one more ideological ally. We have to, in my judgment, stick by the precepts that I've elaborated. I will do everything in my power to prevent one more ideological ally from joining Roberts and Alito on the court. Thank you.
And that's really what everything comes down to. It's all ideology. They are not ideologically aligned with me, therefore, I'm going to tank the nomination process. This is 2007, folks. President George W. Bush wasn't even in his last year in office, and already Senator Chuck Schumer was saying, nope, we're not going to have any more nominations. Nope, it's not going to happen. So when Mitch McConnell comes out and says the same thing, Democrats, don't get all uptight about it. This is politics. Now, we want to talk about politics. We're going to show you one more clip here. Very quick clip from 1991, almost 25 years ago. This is Supreme Court Justice Clarence Thomas at his nomination hearing, and that was a testy affair. I remember that one. Take a look.
When I stood next to the President in Kennebunkport, being nominated to the Supreme Court of the United States, That was a high honor. But as I sit here before you, 103 days later, that honor has been crushed. From the very beginning, charges were leveled against me from the shadows. Charges of drug abuse, anti-Semitism, wife beating, drug use by family members, that I was a quota appointment, confirmation conversion, and much, much more. And now, this. I have complied with the rules. I responded to a document request that produced over 30,000 pages of documents. And I have testified for 5 full days under oath. I have endured this ordeal for 103 days. Reporters sneaking into my garage to examine books I read, reporters and interest groups swarming over divorce papers looking for dirt, unnamed people starting preposterous and damaging rumors, calls all over the country specifically requesting dirt. This is not American. This is Kafkaesque. It has got to stop. It must stop for the benefit of future nominees and our country. Enough is enough. I'm not going to allow myself to be further humiliated in order to be confirmed. I am here specifically.
Well, that was 1991. We got one more clip we want to show you. We are running out of time. This is where it all began. Robert Bork's hearing in 1987. Let's take a look.
Republican Senator Alan Simpson, a Bork supporter, went on to give Bork a chance to expand on what he said yesterday to the committee on what the Constitution has to say about a right to privacy.
We've now talked about contraception, homosexuality, sterility, I don't know where else, sexual preference, sexual gratification. No telling where we'll get if we keep struggling along in this area. But those are important things. I don't even belittle that. But it's all been taken out of context, every bit of it. I don't think you had an appropriate time to respond on the issue of privacy. And especially with regard to the Griswold case and the Skinner case. And I guess I want to be sure, because there was a line of questioning yesterday which I gathered, and I think it was our chairman, and it was a good line of questioning. It was, well, if you don't embrace these things through some method, how are we going to get to that point? How do you protect? Well, I want to ask you if it is fair to say that you believe that privacy is protected under the Constitution, but that you just don't believe that there is a general and unspecified right that protects everything, including homosexual conduct, incest, whatever, and you mentioned that yesterday. Is that correct?
That's correct, Senator. I think the fact that I didn't get everything I wanted to say out was my fault, because I was trying to discuss with Senator Biden and others the constitutional problem. But I think it requires a fuller answer than that, and that is this. No civilized person wants to live in a society without a lot of privacy in it. And the framers, in fact, of the Constitution protected privacy in a variety of ways. The First Amendment protects free exercise of religion. The free speech provision of the First Amendment has been held to protect the privacy of membership lists and a person's associations in order to make the free speech right effective. The Fourth Amendment protects the individual's home and office from unreasonable searches and seizures and usually requires a warrant. The Fifth Amendment has a right against self-incrimination. There's much more. There's a lot of privacy in the Constitution. Griswold, in which we were talking about a Connecticut statute which was unenforced against any individual except a birth control clinic. Griswold involved a Connecticut statute which banned the use of contraceptives. There was no, and Justice Douglas ended that opinion with a rather eloquent statement of how awful it would be to have the police pounding into the marital bedroom. And it would be awful, and it would never happen, because there is a Fourth Amendment. And the police, nobody ever tried to enforce that statute, but the police simply could not get into the bedroom without a warrant. And what magistrate's going to give the police a warrant to go into search for signs of use of contraceptives? I mean, it's a wholly bizarre and imaginary case. Now, let me say this.
Yield at that point, just for clarification.
Yes, certainly, Mr. Chairman.
If they had evidence that a crime was being committed.
How are they going to get evidence that a couple are using contraceptives? Wiretapping?
Wiretap.
They
have a legal wiretap.
You mean to say that a magistrate is going to authorize a wiretap to find out if a couple is using contraceptives?
They couldn't they, under the law?
Unbelievable. Unbelievable.
No, I understand that, but under the law, Judge, could they not have? It was a crime, correct?
It was a crime on the statute books which was never prosecuted. Never.
Well, the fact that it wasn't prosecuted did not mean that it wasn't a crime, does it?
I have more to say about that, whether it was a crime or not.
Let's assume they were drug dealers. They were also accused of, there was evidence that they're involved in some other illegal activity, and there was a wiretap.
And they hear discussion of contraceptives?
Yeah.
Nobody is going to get a warrant for that, and no prosecution is going to be upheld for that. And I'd like to go on to that point, because
Thank you, sir.
I think the law was an utterly silly law. But my objection is simply to the undefined nature of what the court did there, and I've tried to illustrate that for you by asking you whether you would vote for a statute that said nothing more than that everybody has a right of privacy, and the court shall enforce it. I don't think you would.
In Robert Bork's America, there is no room at the inn for blacks and no place in the Constitution for women. And in our America, there should be no seat on the Supreme Court.
As much as I'd like to keep Ted Kennedy's statements going, because we are running out of time, I just want to wrap this up here. Democrat activist N. Lewis acknowledged that if Bork's nomination, quote, were carried out as an internal Senate debate, we would have deep and thoughtful discussions about the Constitution, and then we would lose. And New York Times columnist Joe Nocera claimed that, quote, the Bork fight in some ways was the beginning of the end of civil discourse in politics. The anger between the Democrats and Republicans, the unwillingness to work together, the profound mistrust, the line from Bork to today's ugly politics is a straight one. And really, that's the heart of the message today. That it was the Robert Bork Supreme Court nomination that all of this ugliness started from. So if you go back to the clips where we had President Obama asking, where'd this come from? It came from the president's party in 1987 in a fight over a Supreme Court nominee. Now, we are going to be coming back to this topic in future shows. This is only part 1. I don't know when we're going to be doing part 2 or part 3 or part 4 or part 57 or what do they have? Jaws 19, so we'll have Supreme Court 19. I don't know, but I do know that this is going to be one of our comeback 2 themes for future shows. But that's it for this week. Have a great week, and we'll see you next week on North Star Oasis.